The Supreme Court just dropped a hint about its next big Voting Rights Act case, one that could redraw the rules of American elections.
On August 1st, 2025, the justices quietly broadened a dispute over Louisiana's congressional map. By doing so, they yanked a bedrock principle of the 1965 Voting Rights Act into the spotlight. When lawmakers try to fix racial discrimination in voting, are they themselves violating the Constitution by considering race at all?
Here's how we got here. After the 2020 census, Louisiana's Republican-led legislature produced a 6-seat map with just one majority black district, even though roughly 1/3 of the state's residents are black. Civil rights groups and black voters sued under Section 2 of the Voting Rights Act, arguing the map illegally diluted black voting strength. 2 lower courts agreed and ordered a remedy: draw a second majority black district. The legislature complied in January 2024, and that new map was used in the 2024 elections.
Problem solved? Not quite. A fresh lawsuit arrived from a group of self-described non-African American voters. They claimed the revised map is an unconstitutional racial gerrymander because race was the dominant factor in its design. Their argument rests on the 14th Amendment's promise of equal protection. Government, they say, can't sort citizens by race, even with good intentions.
That left Louisiana caught between 2 legal commands: violate Section 2 if you ignore race, or violate the Constitution if you don't. When the case first reached Washington, the Supreme Court punted, asking for more arguments next term. Then, in its August order, the court sharpened the issue, instructing both sides to answer one direct question: does deliberately creating a majority-minority district violate the Constitution?
That single sentence transformed a regional fight into a national showdown. Section 2 has long required new districts when minorities are large, compact, and politically cohesive enough to elect candidates of their choice. If the court embraces a strict, colorblind approach, that long-standing remedy could disappear, reshaping every future redistricting battle. The stakes extend far beyond Louisiana. Without Section 2's protections, minority voters would lose one of their last best tools to challenge maps and laws that dilute their power. State legislatures would face a paradox: draw race-neutral maps and risk disenfranchising minority voters, or draw race-conscious maps and risk constitutional defeat. Either way, federal courts could end up policing fewer and fewer voting rights claims. So, what happens next? Both sides will file new written briefs this fall. Oral arguments are expected during the court's upcoming term, with a decision likely by June 2026. A narrow ruling could tweak redistricting standards. A broad one could upend them entirely, shifting the balance of political power in Congress for years to come.
That's why a seemingly routine order has election lawyers and civil rights advocates on edge. The Supreme Court's next word on the Voting Rights Act may redefine not just how lines are drawn on a map, but who ultimately gets a voice in American democracy.